Excellent. We are on the record. It is 18cv27149. Byers versus Estate of Nichols and Patrick and Heather Dyke. Mr. Dyke's on the phone on behalf of himself. I have Ms. Ostrom on behalf of plaintiff. Scheduled for a status conference this morning, and looks like, just based on what I've got in the file, that you folks are still dealing with some discovery, at least as recently as a few weeks ago. And then we have a few motions pending that, if the parties are prepared, I think we can resolve this morning.
Okay.
Ms. Ostrom, from your perspective, are you prepared to try and address those motions?
Yes, Your Honor.
Mr. Dyke, are you as well?
Depending on which ones there are. I think
Well, I've got your motion to reverse my order striking the pleadings filed by the estate, then a couple of motions to compel, actually maybe 3 motions to compel.
Yes, I'm especially ready for the motions to compel.
Okay. Want to deal with the one that was filed first, which was the motion to reverse that order striking the pleadings from the estate. Mr. Dyke, I have reviewed that motion as well as the plaintiff's response. Did you have anything else you wanted to add to that by way of argument?
No.
Okay. Ms. Ostrom, did you have anything you wanted to add by way of argument to that motion?
No, Your Honor, we stand by our response.
Okay, and I am going to deny that motion. We addressed the issue that Mr. Dyke has raised in the, effectively the motion to reconsider when we dealt with the original motion. At this point, the estate's still been defaulted in the case. I think that's the appropriate resolution of that one, which would then move us on to the motion.
The question.
Go ahead, Mr. Dyke.
Why are you opponent, even though it's not UTCR compliant? Can you just restate that reason?
I'm sorry, I wasn't sure I understood what you said there.
It wasn't UTCR compliant.
And we addressed that issue, the issue with regarding to conferral. We addressed that at the time.
Can you refresh my memory?
I don't want to plow the same ground twice, Mr. Dyke. You're certainly welcome to get a copy of that prior hearing, and you can review that if you like, but we did address that issue. So let's move on to the motion to compel the request for production set 1. Again, I have reviewed that motion. Mr. Dyke, was there anything you wanted to add by way of argument to that one?
I think this was originally requested like in December.
The original request?
Yes.
Yeah, it looks like December 21st, at least, is the date that I have on it in our file. Was there anything else you wanted to add by way of argument?
No, sir.
Okay. Ms. Ostrom, anything else you'd like to add?
Just that we've responded to this motion to compel discovery. We have produced responsive documents to his discovery request, and as we get more of them, we will continue to supplement.
Do you have any idea when that might wrap up? You might conclude with that production?
Hopefully very shortly. I'm still waiting for documents from the plaintiff himself. To the extent that there are any, he's produced what he has so far, and I've just asked him to do a further check.
Okay. Mr. Dyke, anything else you want to add with regard to that?
We were wanting to I thought that if Mrs. Ostrom wanted to send us originals, that would be fine in lieu of presenting originals for our inspection.
Well, it sounds like they've provided copies of what they have so far, and they're continuing to look. Is that, you don't think that's an adequate response? Is that what you're saying?
No, the attorney we consulted with said that we need to inspect the originals and make copies according to the law, as the law provides.
Ms. Ostrom, at this point, are you willing to make copies, or not copies, the originals available for their inspection?
I would have to consult with other counsel on this case. I personally don't have an issue with it, but I'm not the original custodian of this document.
Okay. Just looking through your motion here real quickly, Mr. Dyke. If I can find it again.
of seeking rental receipts. I also asked Mrs. Ostrom to give me a list of the things that they were intending to comply with, and I haven't gotten like an overview of which ones they were intending to comply with, so it's very ambiguous to, trying to get a hold of the status of each request.
May I be heard, Your Honor?
Oh, please.
As far as a list of things that we intend to comply with, we've timely responded to each of Mr. Dyke's discovery requests, and I believe that our responses provide a complete and accurate picture of what we intend to provide.
Your Honor, there's some things they said they're going to comply with, but they haven't. It's been well over a month, so we don't know if they are things they're very tardy on, if those are things they're not going to comply with, or what.
Which is really the purpose of the conferral requirement, so that you can have that discussion about whether or not those are going to be provided, or if they are not, or don't exist, etc. Just let me take a look at one thing. So, Mr. Dyke, is there any particular reason that you want to see the originals as opposed to copies? I recognize certainly that the ORCPs permit the inspection of the originals and copying, although typically parties exchange copies unless there's some particular reason that the originals are necessary. I'm just wondering if you have a particular reason.
Well, Your Honor, I can only imagine, given the conduct of the plaintiff's attorney so far, if I were to ever try to utilize the copies, they might object and call it and cry out hearsay because they're secondhand material. I can't testify about them as a first-hand party unless I have that opportunity to personally inspect them. I'm agreeable to them sending me originals. They can make all the copies for back if they want and to send me the originals.
I don't imagine they're going to be willing to send the originals, but under the rule you are certainly entitled to inspect the originals and copy if you choose to do so.
Yes, I choose to do so, Your Honor.
In which case, I'm going to suggest that rather than granting the motion at this point in time, that you folks chat about a time when you can do that and that those be provided, or if there are particular documents that you want to see the originals of, you identify those and let them know. If it's just everything that was responsive to set one, then I would suggest that you folks attempt to try and find a time when you can get together and do that.
Your Honor, we already conferred abundantly on this, so.
Well, and Mr. Dyke, you've got a variety of discovery requests, some of which it sounds like they're still gathering the documents and ensuring they have complete copies. I'm going to suggest that if you want to review all of those originals, it's going to be best to wait until they have them all, so that you can conduct that review one time instead of multiple times.
So I will have the burden of a third motion to compel if they ultimately don't comply?
I'm actually not going to rule on your motion to compel at this point in time, on this one anyway. Going to leave
so it will remain in place?
If you'd let me finish. I'll leave it open, essentially, so to give you folks an opportunity to come up with a time and place to review those originals once they've got them all. And if that doesn't work out, we can simply set that motion for an additional hearing to address whether or not we need an order to compel.
Your Honor, it's just, they raised a multitude of issues, so this is just one part of the protest. So, I mean, this might address one part of it, but there are other things that they are protesting.
And I'm only addressing what's in your motion that you have filed, which is dealing with your first request, which is that you don't believe you've got all of the documents and also that you want to see the originals. Sounds like both of those things we can get addressed. Let's move on to the motion to compel discovery, the request for admissions set 2. Again, Mr. Deck, I have taken a look at that. Was there anything else that you wanted to add by way of argument to that?
Let me find it here, please. Request for admissions.
Yes.
I have request for reduction number 2. Let me move forward here.
Looks like this was filed on April 1st, and it's a motion to compel discovery, request for admissions, set 2.
Okay, I finally think I have that, yes.
Was there anything you wanted to add by way of argument to that?
Well, the main concern there was I clearly asked for persons with first-hand knowledge to respond, and the plaintiff's attorney responded that the information is based on the plaintiff's present knowledge, and I've only known him to be very uninvolved, deferring to his attorneys. So I know he doesn't have first-hand knowledge, so I would like to compel my request as stated.
I'm looking at the moment for that request, if I have a copy of it. Request for admission.
We request Daniel Byers have a persons or attorneys with first-hand knowledge admit the truth of the following statements of fact. Please indicate the party answering each statement.
Do you know when that request for admissions was? Never mind, I found it.
Originally filed 2/19.
All right. Ms. Ostrom, did you have anything you wanted to add in way of response to that?
We stand by our response, which is that the information that defendants seek is akin to interrogatories, which are not allowed under Oregon state law. To the extent that defendant is unsatisfied with our answers, we understand that, but that doesn't give him extra rights beyond what is guaranteed.
She's saying to identify, I believe, to identify the person responding isn't required by law.
I'm sorry, one more time, Mr. Day?
I think she's claiming that she's not required to indicate who is responding to the statements. If I go back and read that ORCP 45 or 36, it talks about making requests for admissions of different parties. So it seems to render the discovery tool useless if it's totally ambiguous who's responding.
To respond to that, Your Honor, the request for admission says, request that the plaintiff have the person attorney with first-hand knowledge admit the truth of the following statements of fact. This is something that we did when we responded to this request for admission. Beyond that, no further information was requested or is required by law.
But, Your Honor, the plaintiff did not have first-hand knowledge of questions that only the attorneys could answer, such as what was if you look at the first one there, I can find it. At the times when the original amended lawsuits were filed, the plaintiff's attorney, Camilla MacLeod, did not know if the property at 326 West 21st Place was in possession of tenants. There's no way the plaintiff had first-hand knowledge of, what Camilla thought. She could have told.
To the extent that plaintiff seeks this information, he's seeking information protected by attorney-client privilege.
Yeah, and I think that would be accurate, Mr. Dyke, that you've got some issues there with what you are requesting, but also a request for an admission simply requires the party to admit it, deny it, admit or deny in part. They're not required to provide you with additional information, such as an answer to a question And
I understand that, Your Honor.
The admissions are from the party. They're not from the party's attorney. You can't just serve a request for admissions on anyone in existence. It's got to be on a party. So it appears to me they have appropriately responded, at least in terms of the issue that's raised in your motion, which I'm going to bring up here again if I can before I finish saying that.
It says in ORCP 45, the party to whom the request is directed. So I directed my request to persons with first-hand knowledge.
And there's only one party in the case that you have directed this to, which is Mr. Byers. His attorneys are parties.
They're saying he has first-hand knowledge of stuff he does not have first-hand knowledge of.
Well, and so you have a dispute about, I suppose, whether or not he's answered these truthfully, and that's different than something we can address in a motion to compel. If you're aware he doesn't have first-hand knowledge, I suppose he's not in a position to admit or deny. If you've
But they've admitted or denied every request.
in which case they have complied with the discovery request. You have an issue about what they've replied. That's different than we deal with in a motion to compel. So I'm going to deny that motion, which I think then moves us to your motion to compel discovery regarding set 3. Let's see if I can pull up that motion as well as get set 3 in front of me. Okay. Was there
Just a moment, Your Honor, to do the same.
Certainly. Mr. Dyke, was there anything that you wanted to add to your motion by way of argument at this point in time?
I'm just perusing the request here.
Looks like this is the request dealing with title insurance policies.
Oh, yes, yes.
A title insurance and a title insurance claim. I think those are the two documents or two categories of documents you were seeking. Anything else you want to add to your motion by way of argument?
I think, as I say, the ORCP clearly indicates the discoverability of insurance documents.
Ms. Ostrom, anything you want to add by way of response?
Again, we stand by our pleadings, which is that these documents have no relevance to a claim for adverse possession or any of the counterclaims raised by defendants.
Objection, that sounds like perjury to me.
How are these documents relevant to your claims?
If you get in an auto accident with somebody, the insurance of the other party very much factors into what happens and how it's resolved.
Mr. Dyke, that may be true, that the insurance has some impact into how the case is resolved in terms of who's paying what ultimately, but the insurance policy is not relevant to the underlying case, which is whether or not someone's liable for the automobile accident, whether someone was injured, and if injured, what are their damages. The insurance is not relevant and not discoverable in that type of a case typically.
Well, you know that if the adverse possession case doesn't go through, they have an obligation to the plaintiff. So there's other ways that this could, and I say should be resolved by the insurance.
Your Honor, we don't believe that this has any relevance.
It says that in the ordinance that insurance documents are discoverable.
I'm sorry, one more time, Mr. Dyke?
There's right in ORCP 36 clearly indicates the discoverability of insurance information.
You're looking at 36B2?
I can only flip through these notebooks so fast. 36B2, insurance agreements and policies.
And Your Honor, we'd argue that just because such information is discoverable doesn't mean that it's relevant and therefore required to be discoverable in a specific case?
Your Honor, I take offense at her trying to decide what potentially could lead to information of value to us.
But Mr. Dyke, she's certainly free to argue her position, which is what she's doing.
From my understanding of discovery, we can request things that may lead to useful evidence, information pertinent to the case.
That's true, but ultimately I get to determine what that is. I'm just taking a look at the complaint here real quick. Let's see.
You can look at the warranty deed and see it's an insured deed. There's an underwriter that has insured that deed.
Mr. Dyke, I'm not disputing that there's very likely some title insurance that may at some point come into play in how this case gets resolved one way or another. The question at this point is not that, but whether it is relevant to the issues that are outlined in either the complaint or your counterclaim. And in order to be discoverable in some fashion under 36, B2, that insurance needs to be liable to satisfy part or all of a judgment that may be entered into the action or to indemnify reimbursed payments made to satisfy the judgment. At this point, I don't see that would make it discoverable under that based on the complaint. Let me get to your answer.
Until this is all resolved, I don't know that we'll know the full significance of the title insurance.
Your Honor, to me that says that he has no idea whether or not this leads to relevant information.
For instance, if the title policy says that if the plaintiff takes action prior to contacting the title company, then they don't have an obligation to uphold their obligations.
And Mr. Dyke, let's assume that is what the policy says. How is that relevant to your case?
I need to know, Stuart Title has been like hiding behind the scenes on this whole thing. I tried to request their involvement and the nature of their involvement and get contact information, and they're only a party in the background that is funding this. I tried to contact them early on. They basically told me I was irrelevant, and so I definitely want the information from the title company and the title insurance.
And Mr. Dyke, that still doesn't address my question, is how is it relevant to the claims that are pending in this case? Whether you want it or not, make it relevant.
Well, their pleas are that he has no other recourse, and the existence of title insurance certainly is a remedy and a recourse in this dispute.
I'm not seeing that makes it relevant, Mr. Dyke. I'm going to deny that motion to compel, which I think addresses all of the ones that are currently pending. Let me double check.
Is there a polite way to, for the record, object to that decision?
You don't need to object to it, but if you did, you have.
Thank you.
I think that does cover all the outstanding motions at this point in time. Given that we've got at least a few discovery requests that were made just recently, I think I'd like to set this for hopefully the last status conference, and then we can talk about whether we're trying this or setting it to a settlement conference or how we're going to address that. Let's see, what's a good date?
And Your Honor, just for additional clarification, we plan to be filing a motion for summary judgment in the next several days.
Given that, I don't think I'll set a status conference. We'll just wait until we've got that motion and the related responses, et cetera, and schedule it for a hearing once we've got all of that.
Yes, I anticipate this taking a long, long time to get through all this discovery, so we are wanting to accomplish that.
Your Honor, is it possible to state for the record that Mr. Dyke calls me often multiple times a day, leaving harassing and yelling voice messages?
Objection.
Mr. Dyke, I don't think you need to object to that to the extent, for whatever reason, Ms. Ostrom, you need to have that on the record. It is. Sounds like Mr. Dyke has a different view of what's occurring. I don't know that I need to necessarily address that beyond encouraging everyone involved to act in a professional manner regarding the litigation. Ms. Ostrom will look.
Yes, Your Honor.
We'll look for that applies both directions. Ms. Ostrom will be looking for your motion for summary judgment. Once we've got that and the relevant responses, replies, etc., we'll get a hearing scheduled for the summary judgment hearing. I would imagine we're probably going to want to book a couple of hours for that, just given how long some of these other hearings have taken, and that's what we'll do.
Thank you, Your Honor.
Anything else we can address from your perspective?
No, Your Honor.
Mr. Dyke, anything else we can or need to address from your perspective?
Yes, but I don't think it will be accepted. But
Did you have something else you wanted to add?
Heather, do you have anything? No. I'd like to add that Mrs. Ostrom has been very busy, and I can tell you my attempts to contact her. I've asked that she leave information, and she only calls and says, "I'm trying to contact you," and so there's been a lot of back and forth with that, and it just hasn't gone very smoothly.
Okay. Well, hopefully that changes in the future. Thank you, everyone. Have a good rest of the day.
Thank you, Your Honor.
Thank you, Your Honor.